Hey folks, I'm Denise Howell, and next up on This Week in Law, Joshua Landau is with us. He authors Patent Progress, a wonderful patent blog. We're going to talk about patent law cases and legislation, including the concerned citizen who successfully challenged Waymo's LiDAR patent. We're going to talk about women on boards, and if you go to Brown University, just how free is that coffee? Stefan Spida and Matt Curtis, my co-hosts, are here as well, all next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
This is TWiL, This Week in Law with Denise Howell, Stefan Spida, and Matt Curtis. Episode 437, recorded October 5th, 2018. FRANDS with benefits. Hi folks, I'm Denise Howell, and you are joining us for This Week in Law. We are thrilled that you are here with us this week. We have many interesting things to discuss per usual, and a wonderful guest joining me and my two amazing co-hosts. So let's get right into it and introduce you to Josh Landau, who is the driving force behind Patent Progress, a blog at CCIA, and also the patent counsel for that organization, though Josh is here with us today in his individual capacity and not on behalf of CCIA. Josh is a former fellow with the U.S. Senate, a former practicing attorney, and also in his spare time, a sound engineer for a theater we were just discussing before the show started. So Josh, really wonderful to have you on the show.
Really excited to be here.
Tell us a bit about CCIA, what it is, what it does.
So CCIA is the Computer and Communications Industry Association. It's a trade group that represents about 24 tech companies primarily. So some of the larger members, I mean, you've heard of Intel, Facebook, Google, Samsung, but also smaller companies like Cloudflare, but all sort of in that space of technology, communications, the internet. And we're their trade association, which means that we do policy work for them. So not direct legal representation, but everything from Hill work to amicus work to going in, and in my case, since I'm working on patent issues, talking at the patent office about here's what's going on, here are the issues that we see. And that's kind of my role. We also do work in other areas. So privacy is a big area. Net neutrality we're very active in. Digital trade, copyright, all sorts of issues that are really of interest to that community.
Right. And if you're interested in all of the issues that Josh just mentioned, then you might already be familiar with CCIA's great blogs, including Patent Progress, which you primarily author, right, Josh?
Yeah, I'm the primary author. We have occasional guest authors, but most of what's up there I wrote.
Right. And then there's also Project Disco, which tends to be more on copyright-related issues and consumer video choice. And they're all just wonderful sources of information.
I was going to say Disco is really competition issues. So copyright is often viewed as just an IP issue, but it can have serious competition impacts. And a lot of what goes on to Disco is looking at how antitrust works for technology.
Yeah, I've always just found it a wonderful place to stay on top of issues. So if you're not already following along with those blogs, including Josh's, check them out. Also, please welcome back to the show my two wonderful co-hosts. Matt Curtis is here, founder of Pareto Life Sciences and a law student on hiatus. Great to see you again, Matt.
Great to see you again. Excited to talk some patent stuff today, and this will be a good opportunity to learn some more.
And Stefan Spida is here. He is a practicing attorney with the Dorsey and Whitney firm in Seattle, Washington. Hi, Stefan.
Hi, I wish I could be a law student on hiatus. That sounds like fun.
It does, doesn't it? We're all sort of law students on hiatus on this show since we're constantly learning. Maybe that puts us off hiatus as we go through each episode's issues and learn more about them from our great guests. So that's what we're going to do today here with Josh. And since Josh is a patent lawyer and a patent blogger, we're going to start with, surprise, surprise, some patent issues. So Josh, we've got a lot of things to talk about on the patent front, some specific cases that are in the news these days, and also some more general policy discussion we can have about patent law and what's going on. Why don't we start from the general and go to the Pacific, sorry, not to the Pacific, that's where I am here in California, to the specific, and talk about some big issues in patent reform and why it's an important issue that we keep bringing up on the show. You have a post up on Patent Progress about NPEs, non-practicing entities, being more evidence that these are, first of all, these are often known as patent trolls, why they're not good for innovation. So for folks who aren't already familiar with all of the concepts I just mentioned, why don't you bring us up to speed on that front, Josh?
Sure. So the basic idea of an NPE, or sometimes you'll hear patent assertion entity, PAE, or patent troll, they all get used in slightly different ways, but fundamentally refer to some company that doesn't make anything, but does make patents that they then litigate and assert against other companies. And their real business model is licensing those patents out. So the question has always been, what's the impact of that? There's nothing illegal about doing it, but is it good for innovation? Do they pay inventors enough to justify the negative impacts or not? And there's a recent paper from a few professors who've been looking at a lot of evidence, and I wrote a bit about it and linked to the paper. It's definitely worth reading, looking at what happens with practicing entities, what happens with operating companies once they've been sued. How do they change their spending on research and development? How do they change their spending on new products? And the answer they came up with is that there's a real negative impact, that these firms generally reduce their spending. They reduce how much they're willing to spend on research and development, which makes sense. If you think there's a risk that your research and development spending is just going to create new risks for you, it ceases to have as much value. So you see this negative impact. The counter question is, well, the NPEs, at least in theory, do pass their money. They have to pay for those patents somehow. So the inventors at some point are getting rewarded in theory. The problem is that theory doesn't seem to play out. There isn't any real marker that NPEs actually pay inventors in a way that generates more innovation.
Right. And then when they get the patents, other people who are attempting to innovate often find themselves ground to a halt by the litigation process.
Yeah. So, I mean, by litigation and also by the threat of assertion, and to a sort of a higher level extent, the idea of a blocking patent is that a patent doesn't allow you to do anything. All it allows you to do is prevent somebody else from doing something. So the fact that I own a patent, I don't own a patent, but if I did own a patent, it doesn't mean that I can do what I've patented if somebody else holds a patent on something that I need to do what I patented. So the simple example is if somebody else has patented ham, I could still patent a ham sandwich, but I can't make a ham sandwich without getting a license from the ham owner. What that winds up doing is that if there's a lot of patents in a space, it becomes harder and harder to build on it, to innovate, because there's always the risk that some basic building block has been patented and that you won't actually be able to do anything once you've innovated, even if you go out and seek your own patent.
Right. And I guess one of the answers to that problem is the whole open source movement and having certain intellectual property ideas that are available for use because they're not tied up with patent. That movement has been around for a long time. What do you make of its current health and welfare?
I think the open source movement is, I'm trying to think of how to say this. I think that it's really, at this point, it's proven that it is a viable model. There's no, different projects may come and go, but the idea that open source is a workable way to develop software is pretty much, I don't think anyone could really argue with that. But that movement still has some problems with patents. The fact that something is open source doesn't necessarily mean that it isn't going to be challenged by a patent. It's something that I think a lot of open source companies think very deeply about. So Red Hat is a CCIA member, and it is an issue that they care about. They worry. There's the blanking on the meaning of the acronym, but the LOT network is a lot of open source companies have participated in, and it's basically a commitment against their patents ever being asserted against open source products, particularly Linux, but in general, open source.
Right, because the ham sandwich problem doesn't go away just because you're dealing with something that's been open sourced. If all the patents involved in what's been open sourced haven't been cleared, then you're still going to be in trouble.
Right. I mean, a lot of the open source licenses have started to think about this issue, so they make sure that contributors to the open source project give an effective license to users of the project. But they can't bind somebody who didn't contribute to the project. They can't bind somebody who didn't participate. And in some ways it's analogous, and I think we'll talk about this a little later, to standard essential patents and how that interaction between contributors to the standard and their patent ownership works.
Right, and don't they make the contributors to the open source project also warrant that their contributions are original and aren't relying on other IP?
I think that's usually more in the copyright context, but and it also depends on the open source project. Some don't make any warranties whatsoever. I think the larger projects are much more careful about it, especially now.
All right, well, I'm sort of veering us away from patent trolls here and whether or not they're good for innovation. Matt, did you take a look at this, and do you have any questions for Josh?
Yeah, I think that, it's an interesting area. I think that, just to broaden the perspective, there is academic debate about the value of patents in general. So, the subset of people who aren't practicing with their patents, certainly would come under greater scrutiny. What are some of the structural things that we could do? You mentioned that this is something that, buying a patent and then using it as a litigation tool is completely legal. So what are some of the structural ideas that have come about to limit the negative effects of patent trolls or NPEs?
I mean, there are quite a few. One is what's called a working requirement, which is basically just a requirement that in order to assert a patent, you actually have to be doing something with it other than asserting it. You see this to a limited extent in the ITC, in the International Trade Commission, which has a domestic industry requirement. But because of the way that domestic industry requirement is applied at the ITC, you still see some non-practicing entities at the ITC. They can claim licensing activity. The other problem you run into there, and this is a legitimate concern, is universities are non-practicing entities, but they are also generally actual innovators. They're creating their own patents that they then go out and, in some cases, assert, and in many cases successfully. I know the UC system, the University of California system, has a huge licensing program. My alma mater, the University of Michigan, has a licensing program. Wisconsin, a lot of universities license their patents very successfully because they tend to have actually innovative technologies, but they wouldn't qualify for a working requirement. Structurally, I think the biggest issue is really just making sure that the patents that are out there are valid and are actually new. That's the bigger concern. NPEs, a lot of the time, they rely on sort of corner cases. They rely on patent litigation being expensive, which it is, and they rely on that to extract settlement values. And they rely on broad patents that probably shouldn't have issued because they're easier to assert. They're easier to win a case on when the patent is and this is a software patent problem in particular, when a patent is kind of meaningless and you can argue it means whatever you want, it becomes very easy to say that somebody's product does what the patent claims.
So can you quickly just give us, a lot of our listeners aren't familiar with the patent process. Could you give us an overview of it seems like if you're granted a patent, therefore, that's a statement that you've made something new. Can you walk us through how, some patents get through that aren't actually patentable material?
Sure. So the basic process is you go to a patent attorney. They write up an application with some set of claims when the claim is what you actually claim to own. The application, the specification, the long description, all the drawings, those are just to describe information about your patent. So you'll see headlines sometimes about Apple patented this or Amazon patented that, and they'll look at the title, but the title has nothing to do with what they actually claim to own. You have to look at the claims for that. So you take your claims, you go to the office. Sometime in the next couple of years, the office will get back to you, and the examiner will have had a certain amount of time. It depends on exactly which examiner, what the area of technology is, but somewhere on the order of 15 to 30 hours, maybe a little bit more for some really complex technologies, to go out and look for prior art, for documents that existed before your claimed invention that disclose what you have claimed you invented. And the examiner will say, well, I looked, I found this document, and it shows everything that your claim says, so you don't get your patent. And the applicant will come back and say, well, okay, I'm going to change my claims in this way. Or they might say, well, you don't really understand what that prior art reference really discloses, or you don't understand what my claims mean. And that negotiation happens back and forth. The examiner does have a very limited amount of time throughout this. I have, and I think Stephen has as well, litigated patent cases. I would regularly spend literally hundreds of hours looking for the right prior art to invalidate a claim. An examiner gets on the order of 20 hours to find the prior art and write up their response to the applicant and deal with all the paperwork, which all takes time. So they're getting significantly less time than private attorneys will spend later on. That's a large portion of the reason. Part of it is just resources. They only have so many resources. There's actually, I have a blog post going up soon, hopefully today, on a new prior art archive that Cisco and Google and MIT and the USPTO collaborated on. And the idea there is to provide prior art resources outside of patent documents. Examiners tend to rely on patent documents, but there's a lot out there, especially on the tech side of things, that's product manuals, web pages, standards proposals, all the sort of non-patent but really technically important documentation. So I think the big problem at the patent office is just a resource limit. It's examiners only have so much time. Their job is not that easy, and they have a limit on what they can find. So at the end of the day, there are going to be some patents that slide through because the examiner just couldn't find the art that should have been found based on these restrictions. And in some cases, I mean, examiners are humans. They make mistakes. Some of them try harder than others. And sometimes an examiner will let something through because the applicant just isn't going to take a no for an answer. So there's no way for an examiner to say permanently, okay, this is not going to go. This patent cannot be granted. The applicant can always come back, can always make a new proposal, make a new argument.
So it almost sounds like in some instances, the patent examiners are sort of bludgeoned into submission by applicants who just won't go away.
I mean, I think some of it is, like I said, it's a resource allocation issue. An applicant, especially an applicant who's well-funded, can say, well, I'm going to spend a lot of money to try to get my patent. And I think examiners, not intentionally, I don't think any of them are saying, this isn't valid, but I'm just going to give it to them so this applicant will go away. But I think after a certain amount of time, there's a certain, I'm sick of this, let me try and find something, let me find anything that I can legitimately give to them or that I think I can legitimately give to them. And maybe they don't put in as much effort at that point.
And then they know that down the line, just because a patent's been granted doesn't mean it's going to withstand scrutiny and the various other processes that are in place to invalidate it down the road.
Yeah, and I mean, I think that that's important as well because they know that there are various processes for review, and they know that when patents are reviewed, and part of this is selection bias. So I think this number is not accurate for all patents out there, but I think that the subset of patents that are litigated back and forth that are used in assertions, about 45% of them, 35 to 45%, depending on the venue, get invalidated. So there is a significant portion, at least on the border, of patents that come out that probably shouldn't have come out.
So you have a post on improving that landscape, a paper that was written by a couple of former patent examiners. Do you want to outline for us what their suggestions are?
Yeah, I mean, their biggest suggestion is, so examiners go through a few phases in their career. They start out as basically junior examiners. Everything they do gets reviewed. And they can't sign off on certain things. They can't sign off on office actions for a while. They can't sign off on issuing a patent. To get that signatory authority, they go through about a 2-year review process. And during that review process, what they are putting out, their work is heavily scrutinized in a way that it isn't at other times. And their promotion is dependent on what comes out of that review. So if you do a bad job during your review period, you don't get promoted. And it turns out when your work is being double-checked at a much higher rate and with much more scrutiny and you have something on the line personally, your work improves. Examiners don't exhibit this behavior. They don't exhibit this improvement when their work is more heavily reviewed, but there's no personal benefit on the line. So I think part of it is just tying back the examiner's promotion potential or bonuses, like their own personal interests, to getting it right and doing more review of their work, because there is not really a lot of review going on of examiner work.
Okay. Anything else that they've put out there?
That was the major proposal from the examiner's paper. There's also some work that's been done, and I don't know if it's in our rundown, but I can find a link for it very quickly, that I've also written about by a couple of professors, Professor Melissa Wasserman, who is at UT Austin, and Professor Frakes, who's at Duke, if I remember right. And they study sort of structural issues at the office. So one of the things they've studied pretty heavily is how much time examiners get. And that time changes, as I mentioned, based on the examiner's seniority. So as an examiner gets more senior, they get less and less time. And that slope is probably too aggressive. They've done some studies that really strongly suggest that senior examiners probably should get more time than they were given. That the sort of the baseline, you do get better at searching for prior art as you get more senior. You probably can't type any faster. The basic sort of, I've got to do the type out my office action. There are some basic searches. There's the basic paperwork. That time is probably fixed. So as examiners lose time, their grant rate goes up, suggesting that there's a correlation between how much time examiners get and whether they grant on the margins. Another paper that they've worked on, I'm going to find their summary paper. Another paper they've worked on is dealing with the Patent Office's fee structure. So the Patent Office funds itself. All of the money that it spends, all of the examiner pay, all of their computer systems, everything comes out of fees that are paid by patent applicants. But they don't actually fund things in these sort of direct correlation. They don't say, well, examining a patent costs this much money, so that's how much we're going to charge for us to examine a patent. The examination is actually significantly lower. It's somewhere on the order of 50% of the cost of examination. They make up for that with a pair of other fees, issue fees and maintenance fees. So the issue fee is once you've gotten your patent approved, you pay that so that it's actually issued. The maintenance fee is at 4 years, at 8 years, and at 12 years after grant. You pay a maintenance fee to keep your patent in force. The maintenance fees have a benefit in that patents that aren't being used might not be maintained, and they'll come back to be able to be used by other people if they want to try and pick that work up. But the issue fee is much more than it actually costs the office to issue a patent at this point. And they use that money from the maintenance fees and the issue fees to subsidize examination, which means that there's actually sort of a financial interest to the patent office in granting patents. They have to grant a certain amount or they can't actually meet their budget.
Right.
The problem with that is pretty obvious.
The bulk of the fees you just mentioned come after the fact, after issuance.
They only come if the patent issues. If the patent doesn't issue, they don't get those fees.
Yeah.
Which creates an incentive. And again, and I don't think Frakes and Wasserman are suggesting that this is an intentional thing on the part of examiners, but they show evidence that in times when the office has had budget stress, grant rates go up. Now, there are a few mechanisms that they've proposed, and I don't think they're saying that any of those are for sure correct, but anything from leadership kind of pushing a little higher grant rate as, guys, we need to get our grant rate up, to small changes in policy. It's not going to change things. A new cancer drug is getting through either way, and aspirin is not getting through either way. But stuff that's on the margin, things that are on the border, that's where these things really can have an impact. So there are these structural issues to look at as well. And the Patent Office's authority to set its own fees is actually currently expired. There's a bill that went through the House and I don't think has been taken up in the Senate yet that would renew that authority. The office has just used that to adjust their fees in roughly the same structure, but they could very easily say, we're going to fix our structure using our fee setting authority. We could raise our examination fees to mirror the actual cost of examination and reduce issue and maintenance fees to mirror those costs as well.
That's really fascinating. I hadn't thought of any of this stuff before. Stefan, do you have any questions for Josh on either patent trolls or patent quality issues that we've been discussing?
More of a general observation, and maybe it'll lead to a question. And one of the things that I've always struggled with in the research that's done on patent inefficiencies, either in the prosecution or litigation side, is that the empirical basis for a lot of the conclusions always strikes me as a little bit shaky. For example, conclusions about rates of innovation I find to be a little hand wavy in terms of how you establish a decrease in that. Are you just looking at money invested? Are you looking at the number of patents that are being issued out of a particular company? Those metrics end up mattering. And just to give you one example of how it could matter and how complicated this can get, if your premise is that weak patents create inefficiencies in the system when they're issued because they can be asserted in ways that are damaging to innovation, then a decrease in innovation measured by a decrease in the number of patents that are coming out of an organization may actually have a long-term effect of increasing innovation by the same metric, because there are fewer patents entering the stream that are going to be asserted in litigations downstream. So I know that was a mouthful, but my point is individual metrics of innovation rates are very difficult to actually correlate to meaningful progress, because whatever you choose to look at, whether it's the number of patents that are coming out of an organization or how much it's putting into research, it can be very difficult to normalize that over organizations, and it can be very difficult to predict what the long-term consequences within the patent system are going to be of certain developments. So, like, as the example that I gave, if a company is making fewer patents, then maybe that means 10 years from now there's going to be less patent troll litigation, because there's going to be fewer patents that they have sort of bundled up and sold off to patent assertion entities. So I just see the empirical basis for some of these conclusions to be a little bit shaky and a little bit, you kind of get what you want out of it. And so I'm always a little bit skeptical about very definitive statements about, the patent system means X for innovation, because it's just, I've never been convinced that the studies properly grapple with all the nuances that are essentially there in the system. So I wonder, Josh, if there's anything you can say to that, specifically to how are these researchers picking the metrics that they choose to analyze innovation rates, and what gives you the confidence that you can rely on those metrics as opposed to others that are being ignored?
Yeah, I think that that's a very good point. Especially, you see a lot of people say, well, fewer patents or more patents have some impact on innovation. And I think asserting that the number of patents that are issued has anything to do with innovation or has anything to do with future innovation is probably completely baseless. And I think academics have a lot of skepticism about that concept as well. When you see rankings of like this company got this many patents, they must be the most innovative in the US. Well, I would be skeptical of that sort of assertion. A patent is not necessarily innovative, and the number of patents has very little to do with how much you're doing. In these particular cases, in these studies cases, so the patent office, the Frakes and Wasserman work looks purely at grant rate at the office. So they are not saying that more patents is good, more patents is bad. All they are saying is that these behaviors at the office lead to higher grant rates or lower grant rates. And if we assume that, we should assume that the structure of the office should not be influencing grant rate in an ideal world. That the only thing that should be influencing it is whether the patent is really new. So their conclusion, I think, is very valid. It is limited to saying this impacts grant rates. I am often skeptical of what comes out of the office. So I think that in general, the structural reforms that would lower grant rates are probably good, but that is the extent of their work. The examiner work, again, was purely linked to grant rate. But again, if examiners, when they have their own interests on the line, tend to grant less, that's a suggestion that probably that's the right route to be taking, that's probably the right results. And then going back, I think, to the first study that we looked at, they were measuring innovation not by number of patents, but purely by how much the company is willing to invest in innovation, how much they're going to spend on research and development, which I think is a reasonable proxy for the impact of litigation on an entity in terms of how much they're willing to put forward on new product development and new innovations.
That's great. All right. Well, I want to highlight a couple of things. Number one is we've been talking about a number of Josh's blog posts and the papers referenced therein. If you want to check those out yourself, we do have all our resources that we've used to put the show together for you available. They are at tagpacker.com/user/thisweekinlaw. And this is episode 437. So you can find everything we're talking about, hopefully, right there for you. And I wanted to mention something else, but it slipped my mind. So I guess I'll just ask if anybody has any sort of final thoughts on the issue of either trolling or changes at the patent office that could improve patent quality before we go on and talk about patents in China. Matt, anything you want to add or address?
Yeah, just want to point out that, some of these structural things do lead to these sort of stories we see. There's one that we have in our rundown about a farmer being, essentially who has relatively nothing to do with the patent troll, but has website and was sent a cease and desist letter for that, or a patent violation for that. And so it seems like some of the people that these issues fall on are ones who are not sophisticated in their intellectual property operations, and it's done on patents that might not be valid. And so that leads us, and we've talked about this before, but the cost of litigation, whether that's through an IPR proceeding or through federal district court, are high. And so these are some of the shortfalls that almost inevitably are going to happen, and I think that's why the patent troll's got the patent troll name, is for some of these reasons.
Yeah, and I'd add on that point, that farm example, I think that's the first farm I've heard of, but that's not unusual. And there's a reason that retail businesses and restaurants in particular have been interested in the patent issue in recent years. It's because their members, as they start doing things, and usually they're just hiring somebody to put their coupons out online or create an app for their restaurant or share coupons for their retail business. But they start to get sued for doing these things, and it becomes an issue that's really relevant to just your random businesses, your average business, small farm in this case. You want to participate in e-commerce, well, this is the risk you suddenly start running. That creates a problem and a real concern.
Stefan, anything you want to add or address before we move on?
Yeah, I think there's a lot of public discourse about patent trolls, and a lot of it is healthy. My biggest concern about it is that it tends to conflate issues that are related but actually conceptually distinct and kind of package them together. And I don't fault the journalists for doing that. It's hard to imagine being a non-attorney and non-patent attorney and plowing through this stuff and trying to come up with something that's totally coherent. So I don't fault them for getting it wrong as much as they do, but there's often a lot of conflating of things that are kind of related but distinct in a way that creates an impression that I think is not quite accurate to people on the ground. Obviously, this farmer example is very striking and very unfortunate. I don't doubt that it's common. It's hard to imagine though changes at the patent office really making much of a difference to that kind of behavior, because as a percentage of the total number of patents that are getting looked at and issued, the amount that actually end up getting asserted in this kind of way, there's such corner cases that you would have to have a very granular policy reform to ever stop that behavior from happening. And any attempt to get at it through, incentivizing examiners to sort of take a more careful look at a patent isn't necessarily going to directly address that, and it's going to have other effects that may not be desirable. So I actually think this is one of the more complicated policy questions in all of patent law, and I think a lot of people share that view. I can't say that there's a sort of a lightning bolt solution that's going to make patent trolls reticent to assert patents against farmers or retail workers or retailers. I mean, and I don't know that those reforms, if they happen, are going to happen at the patent office level. They may need to happen more at a statutory level to knock out some of those behaviors. And it's a successful business model because it is such a thorny area that is really difficult to reform. And I think sometimes journalists create the impression that this is just, those lazy patent examiners, or these guys they're so greedy. The corporations are out there only to make money, and that kind of narrative gets infused into it. And I just don't know that accurately reflects the complexities on the ground. And not sure what can be done about it. It's just, I would encourage anybody who's interested in it to kind of dig in a little bit and familiarize themselves with the landscape, because as a policy landscape, it's actually a really richly rewarding and complex one to consider.
Josh, I'm curious what you think the prognosis is for this patent, or maybe it's a series of patents being asserted by Landmark Technology LLC of San Diego, California, against this particular farmer that we've been discussing, Azure Farms, which has an online store, I guess, where they can sell their products. And, certainly having an online store, this smacks me as something that would extend beyond the farming community to be of concern. This particular NPE has asserted over, I think they filed over 170 lawsuits. So what do you think happens here? Probably 170 federal lawsuits. So probably not too many of those defendants have a lot of resources to fight this. Does it take someone publicizing this and getting involved and throwing more amicus weight into these cases to possibly invalidate the patent?
Yes, the thing I think I would point out is that they've been involved in about 170 federal lawsuits. I follow the patent litigation landscape pretty closely, and they're just not somebody I've heard much about. Mm-hmm. There's enough others out there. And this, I think, goes to Stephen's point about there are a lot of sort of distinct issues here. So on one side of things, you have Landmark and sort of the quintessential, at least based on this story, example of that type of litigant who's really just looking for a quick settlement was MPHJ, who wound up being censured in various ways, having FTC complaints against them, and faced a lot of pushback on their tactics where they were just looking for a quick settlement. But at the end of the day, they didn't really go away until somebody filed an IPR and killed off their patent. Mm-hmm. That may wind up needing to happen in this case if Landmark is going after small defendants and trying to get inexpensive settlements that are under the cost of an IPR. IPRs are cheaper, but the median cost for an IPR, according to the most recent AIPLA survey, was about $250,000. I'm going to guess that Azure Farms doesn't have $250,000 to spend on invalidating a patent if they can settle for $10,000 or $15,000.
Right.
On the other end, you have large-scale NPEs. Intellectual Ventures is probably the best known, but others like Mossade and Acacia, who really are doing serious patent litigation, who are not in it for a quick settlement necessarily, but want to do expensive license agreements. Mm-hmm. So I think there is you have to look at both sides of it. There are things that you can do that will fix this sort of low-hanging nuisance litigation that won't work for high-end patent trolls. And there are things that you can do with high-end patent trolls, like the IPR system has really helped in that sphere, because that's generally against defendants who have enough money to file an IPR or more than one if they need to. But if you're doing this sort of low-hanging nuisance litigation, IPR is not necessarily a useful technique.
Right, because the person has to be able to initiate the IPR, and that, as you mentioned, is a pricey process. That stands for inter partes review, for folks who weren't listening to, just a few episodes ago of This Week in Law, where we talked a lot about IPRs and described that process. All right, so we're going to put our first MCLE passphrase into this episode of This Week in Law. It is going to be worthless China patents, because that's what we're going to discuss next. Apparently, there is a strange dichotomy in China where the kinds of fees that Josh was discussing just a moment ago are having an interesting result on the health and welfare of the patents filed in that country. China apparently prides itself in filing the largest number of domestic patents of anywhere. But then they tack on fees after the fact, maintenance fees, et cetera, that people don't want to undertake. So most of their patents seem to go away in 5 years or so. So it's an interesting dichotomy of, yes, we're going to file and have issued a ton of patents, but they're not going to have a lot of teeth because they're going to go away. We don't see that happening here in the U.S., I take it, Josh?
Well, that's a funny story. It depends on the patent owner. So every year you get the sort of like, this company has the most patents. Lately, it's been IBM. IBM, I don't know that they lose 90% of their patents. I'd have to go back and look at what the exact number is. But they don't maintain a significant number of their patents. They choose not to pay the maintenance fees on a significant portion of their patents. That isn't necessarily behavior of other patent owners. So Samsung is usually number 2 or number 1 if you combine all of their various subsidiaries together, and they tend to maintain their patents. IBM tends not to. So I think that some of it is what the strategy behind obtaining the patent is. IBM, I think, to some extent has a lot bound up in being this big patent holder, in having a lot of patents, and sometimes those patents are being obtained not so much for the technical value of the patent as for, well, we really just want to have a big patent portfolio. We want to be able to say we had the most patents. We don't need any particular patent to be good, and we'll figure out if we really care about it 5 years from now, but we want to get it for now. And that's not completely unusual in patent prosecution to be told, the scope that we don't really care too much about what the actual issued patent looks like. We really care about getting a patent at all so that we can say, hey, here's a patent. You see that in large companies who want to pump up the size of their portfolio. You see that in small companies who really just need to be able to say, yeah, I have a patent on my technology in order to try and obtain investment in their company.
All right. Does China have a patent troll issue the way that we do here? Does their system permit that?
Yeah. So there's actually a story that just came out about an American entity that owns Chinese patents. It's called IPEL, which stands for Innovative Patents Ethical Licensing, which I think is a hilarious name for an NPE, but that is asserting a set of Chinese patents against ASUS. And they're absolutely, and they're openly, and they will admit to being an NPE. They're not saying we practice. So there's nothing in the Chinese system barring this. What's kind of pushed it away in the past has been two things. One has been a perception that the Chinese patent system, that the Chinese IP system in general, has not been strong, that you can't really enforce there. I think that perception has gone away over the past 10 years. There also have been concerns over whether China has a home court advantage, over whether Chinese companies are given an advantage. Again, I think that perception has been reduced over the past decade or so. And the other has to do with the U.S. system is unusual in that we will award a lot of money for patents that other countries won't award. You see the awards coming out of Europe, you see the awards coming out of Korea, and they're significantly smaller, like multiple orders of magnitude smaller. China does at least temporarily, at least potentially offer injunction relief, saying you can't make this product, you can't sell this product, which can be a much bigger threat, especially if you manufacture in China. So I think that as the Chinese system becomes more respected and as litigants become more comfortable litigating there, you'll see more uptake in that system, especially as the U.S. system has become less friendly to NPE litigation.
Yeah, it's almost intellectually dissonant to think of China as being a place where patents are going to be honored and enforced, since it has such a reputation of being sort of fast and loose with its intellectual property allowances. But maybe that's more for adopting the IP of other nations as opposed to their own patents that are filed in their own system. Do you think that's what's going on there?
I think that's some of it. I think some of it is an effort by China. And this is actually, if you go back to the founding of the U.S., you had a very similar situation where right at the beginning, we were very happy to steal technology from everywhere in the world. Mm-hmm. If you were an American, your technology got protected. But if you could steal technology from the British and use it in the U.S., good job. And we benefited from that. And then down the road, as we became more and more of a technologically innovative country, we started to be more protective of technology in general. I think China has gone through some of the same development. They were much more interested in being unprotective of technology when they were trying to build up their country and their technological base. Now, as Chinese companies become more technologically innovative on their own, they are trying to achieve more protection in China.
Yep, that makes perfect sense. Stefan, any thoughts?
A lot of people, I think, have heard the phrase "war is diplomacy by other means," or some variation of that. And I think you can kind of apply that to patents a little bit. That fundamentally, the patent system, when people hear about it, what they're hearing about is often patent litigation. But fundamentally, the system is intended to be a function of business and help companies win investments and enter into licenses to advance innovation. When you hear about the litigation, you kind of think about that as a separate piece of the puzzle. It's not as though it's not related to the business strategies that companies are executing on. And I think it's sort of useful to think about patent litigation as just a continuation of a business strategy by other means. And seen through that lens, what's happening in China is sort of a rational development in sort of a sophisticated entrenchment of business norms across cultures, and it makes perfect sense from that perspective that IP litigation should start to flourish in that environment where the business reality takes it to that point. So I wouldn't necessarily think of it as in tension with the Chinese reputation. It's more just a further flowering of that business reality.
Right, Matt?
Yeah, I think the other interesting part of this article is that you're looking at incentives that the Chinese government was giving to private organizations to get patents, and whether those refer tax incentives or direct payments. What you tend to see when you have incentives for something is you see flow overs, and so you'll see companies filing for patents that otherwise wouldn't have, and filing for less important patents that they ultimately are going to abandon. And I think we see some of that in the United States too, with specifically within universities. We talked about tech transfer offices a little bit earlier, and only about 30 of them throughout the United States are actually profitable, but we see them operating in most universities and getting a lot in patents for them. A lot of that has to do with like internal structures of how you get money within a university, and that's through grants. And grants tend to be offered to professors who are doing especially in the biological sphere that are getting patents. And so we do see I think that universities are relooking at their strategies for intellectual property because of that. They get a lot of patents, but only the big blockbuster ones are the ones that actually make money. So it's always an interesting thing when you're giving an incentive to have someone get something that blocks other people from doing things. The patent in of themselves are a grant of operating a business or licensing a business. So it's just, as Stefan mentioned earlier, it's a very complicated public policy debate, and one that you really have to think through when you're going to give these sort of incentives.
Yeah, you could call it an update of publish or perish to patent or perish. And I think that's not just at universities. In large corporations in the U.S., there are often incentives to patent. I worked at an automotive supplier, and we certainly had incentives to file patent applications, including incentives to the engineers who came up with the idea, which made us more likely to go to legal and say, hey, here's an idea. Do you think it's patentable? And sometimes they would say yes, and sometimes they would say no.
Okay, we were going to talk about some specific patent developments in various cases as well. Let's look first at Apple and Qualcomm. Speaking of things made in China, Apple and Qualcomm have had a dispute about various Qualcomm chips used in Apple phones. And why is this pending in the ITC, first of all, Josh?
So they filed in the ITC. So there are Qualcomm cases in the ITC, in various district courts, in various places around the world, including in Germany right now. Mm-hmm. So there's sort of as Stefan was saying, patent litigation is often part of a business strategy. I think that it is important to realize that this Apple-Qualcomm case is part of a larger dispute, basically over how much Apple should pay Qualcomm. and how much Qualcomm should make for the technology that it's contributed. It's in the ITC because Qualcomm is saying we don't want Apple's phones that have Intel processors to be imported into the US. And the ITC is a venue that allows you to prevent importation. Qualcomm is aware that because most of their patents are standard essential, they would have a very hard time in district court getting an injunction against Apple's phones. But because, as you said, Apple's phones are manufactured in China, if you can prevent importation of them, you've effectively gotten an injunction. That's why the ITC has become a more and more popular venue, because you can get these exclusion orders, particularly when you have foreign manufacturing being as prevalent as it is. An exclusion order begins to look a lot like an injunction. So that's why
it
it's
sure
in the ITC.
does. I get it now. Okay, so you mentioned we would come back to the notion of things being standards essential when we were talking about open source earlier. Is now a good time to tell folks what that means and why it means that this case is pending in the ITC instead of district courts in the United States?
Sure. So I should clarify that the ITC case actually is not about standard essential patents. It's part of Qualcomm's larger strategy. The patents they've asserted are, I believe it's a battery patent, a switch patent, and maybe a processor communication patent for communication between the baseband chip and the application processor. But a lot of what Qualcomm is asserting, and really what the basic portion of this dispute, what the FTC's lawsuit against Qualcomm is really about, are standard essential patents. So take a phone, and Apple's not a member. I'm not advertising them, don't worry. But that phone has Wi-Fi. It has Bluetooth. It has 3G and 4G cellular capabilities. It has, in this case, it has the Qi wireless charging standard. There are many standards that are involved in a smartphone. And each and every one has what's called a standards document that people have developed over time that says this is exactly how you operate in order to be compliant with the standard to make sure that everybody's products will work together. And the way those standards get developed is the companies that are involved go and sit in a room and they say, well, here's my proposal for how we should do this. And another company says, here's my proposal. And a bunch of engineers argue for a while. And eventually they say, okay, we'll select this one. Consensus is that we're going to pick proposal A that gets written into the standard. Now, if you're a company, you have a lot of incentive to put your patent into the standard, because if you get your patent into Wi-Fi, you're looking at billions of devices that have to use your patent. In order to avoid the ability for the patent owner to hold up everyone who's using the standard and say, well, you're using the standard, you have to pay me however much I want or you won't be able to participate, standards organizations use IP policies, often what's referred to as FRAND, fair, reasonable, and non-discriminatory. That's typical of the cellular standards, and I believe Wi-Fi operates on FRAND as well. Others, like Bluetooth, use what's called a royalty-free standard, where you can just, if you're participating in the standard, you have contributed your relevant patents. So Qualcomm obviously has a lot of patents that they've declared essential. They've said you have to use this patent if you want to do cellular. And there's a huge dispute, and this is really at the core of the FTC's current case at the FTC versus Qualcomm right now, about who Qualcomm has to license. When they said, we will license on fair, reasonable, and non-discriminatory terms, Qualcomm says that means they get to pick and choose who they license to. The FTC has said, no, that means you have to license to everybody. And in particular, Qualcomm says we shouldn't have to license our competitors. So other baseband chip makers shouldn't be able to come to us and say we want a license. The FTC disagrees. I've signed onto a brief that said exactly that the FTC is right. And Qualcomm, when they said we will give non-discriminatory licensing, meant that we will license anyone. I think that's right. I think that's backed up by law. Judge Koh has the case right now, so we'll see if I'm right in some amount of time.
Okay, we'll keep an eye on that.
Yeah. So at the ITC, the basic issue is Qualcomm has asserted non-standard essential patents. Should back up. The other issue with a standard essential patent is because you've said that I will license on fair, reasonable, and non-discriminatory terms, you have effectively said that you will take money for your patent, that you have given up on the ability to exclude others from using your patent, because you've said, I'm willing to license, I know that it'll be for money, I'm going to license on similar terms to everyone else. It doesn't bar an injunction in district court, but it makes it much harder to show that you deserve an injunction, because part of the idea of an injunction in district court is that there's no other way to compensate you that you're suffering an irreparable harm if you get money damages at the end of the case. And if you've promised a license for money, you can't really say that you've gotten an irreparable harm if you are later paid money. So it's hard to get an injunction in district court with your standard essential patent, which is part of why Qualcomm has gone to the ITC. The ITC is somewhat skeptical of standard essential patents, which is why Qualcomm chose to assert non-standard essential patents in the ITC. But in the ITC case, there is a determination that has not been made public yet. We know what the outcome is, but not the why. And in that case, the ALJ, the administrative law judge, has said there are some public interest concerns about granting Qualcomm's request to exclude competitor products, but we don't know why they've said that. One of the possibilities is that they've said that because they're worried about the antitrust and competition issues of Qualcomm using its non-standard essential patents to exclude products that it's mostly trying to exclude on standard essential patent grounds.
Okay, Matt, any thoughts?
Yeah, and so just to make sure, you gave us the federal district court justification for an injunction, but what do you have to show to get an ITC injunction?
So to succeed at the ITC, you have to show infringement. You have to show that your patent was infringed. You have to show that it's valid. You also have to show domestic industry, which basically means you have to show that there's something in the U.S. that is going on that is research, development, manufacturing, licensing based on that patent. There are disputes about the exact scope of that, and honestly, there are probably some changes that could be made. There's a bill that's been floating around for a little while that would exclude certain types of licensing activity from domestic industry. But the idea is that you have to show, the ITC is a trade court. It's not supposed to be a patent court. It is supposed to be a trade court. So you're supposed to show that you are doing economically valuable things in the U.S., and that therefore your foreign competition that is competing unfairly by using your patent overseas shouldn't be allowed to bring their product into the U.S.
All right, Stefan, any questions or thoughts on the Apple-Qualcomm dispute?
Just to point out that result that we are hearing about, where there's a finding of infringement, but as I understand it, that it looks like they're not going to exclude the products. That split between, yes, you're infringing, but we're not going to exclude, I think that's an extremely rare result. So it'll be interesting to see what happens when the opinion is made public and we can kind of see a little bit more detail, because I'm not sure I've heard of that happening before. Maybe it's happened a few times, but it's not I hope the listeners understand that that's a rare result.
Yeah, well, it's an extremely rare result, and there's no guarantee that the commission will adopt the judge's findings there. The judge has made his initial recommendation. The commission itself will make a final determination. So, like you said, I'm very interested to see what the rationale was, because it is such an unusual outcome. We've seen it a few times in the past few years. The biggest was the Samsung-Apple case, where the USTR overturned the commission's determination in the presidential review period, based on concerns about competition in a lot of ways.
Okay, speaking of rare results, we can't talk about patents in this show without talking about Eric Swildens and Waymo and Uber. For months and months, we were talking about the dispute between Uber and Waymo and trade secrets that were allegedly absconded with by a former employee, and various settlements and arrangements between the companies that did away with this huge litigation between them. Now there's this gentleman named Eric Swildens who has come along and gotten all but three of the 56 claims in the critical Waymo 936 patent that was at the heart of that litigation. He's gotten all but three of those claims set aside. And he's done so just because he didn't think that the patent was valid. He says, I couldn't imagine the circuit didn't exist prior to this patent, he told Wired last year. So what do you think about Eric Swildens and what has happened here, Josh?
I am surprised somebody did it, not because I think that it was a bad idea. I have a lot of admiration for this guy for looking at it and going, I don't think this is right, and spending a significant amount of his own money. It's more that I'm surprised that he spent a significant amount of his own money on this.
Right. What would he have had to lay out to get this done?
So, I mean, the filing fee for I believe, filed an ex parte reexamination. So we talked about IPR earlier, which is it's inter partes. It's between two parties. So you've got the filer and the patent owner. In ex parte, you as a third party file a request with the patent office and say, I have some questions here. And the office looks at it, and then they either decide to reopen prosecution or not to. But all of that further work is between them and the patent owner. The filer of the request never gets to participate again. But those are cheaper than IPR. IPR filing fees are around $35,000 now. Ex parte is around $6,000. So he spent about $6,000 just in fees. I don't know if he paid an attorney to prepare it for him or not. And I will say, if he didn't, I have even more admiration, because those are not easy documents to prepare, especially if you're not a lawyer.
Yeah, it's pretty incredible. He's very clear that he doesn't work for Uber or any other self-driving developer. He had no interest in doing this other than, as you say, Josh, he just thought that Waymo was paying fast and loose with intellectual property they weren't entitled to, as he, interpreted the evidence in the case, I guess. Speaking of rarities, I don't think this kind of thing happens very often. I think folks at Uber are probably thrilled, but for the fact that had they known this was going to come down this way, they probably would have made some decisions differently in settlement, et cetera. Matt, what do you think of all this?
Yeah, I think this is a good opportunity to draw the distinction between patents and trade secrets, in that even though if none of this would have been patentable, it still could have fallen under trade secrets. Trade secrets, it's not mutually exclusive at all. So, if Uber or if Waymo just had, even if it was, otherwise known but not known to Uber, that was not readily ascertainable, some information that was of value, they could have asserted trade secrets on there. So, the trade secrets claim still could conceivably and very likely was still valid in this case.
Good point. Stefan, any thoughts?
I love the kind of intrepid gumshoe aspect of this. It should come with a warning, though. Don't try this at home. You're probably going to waste a lot of your money if you try to replicate this. You will not get the same result. So in case anybody out there listening is thinking that they're going to go out and sink some battleships here, they will not.
Yep.
Yeah. I would add, I think as a sort of larger educational thing here, is I don't think that his view of looking at intellectual property skeptically is at all unusual in engineers in general, particularly in high-tech engineering. It's definitely a sentiment I've heard from people I've worked with on the technical side, down to the point of once calling up an old friend who works at the Internet Archive and asking, hey, do you have these disks from old BBS documents? We think there might be some prior art in them. And him saying, are you working for the patent owner, or are you working for the person trying to invalidate the patent? And when we told him we were trying to invalidate the patent, he said, yeah, absolutely, happy to help out. Making it very clear that answer was dependent on what answer I gave him. So I think that there's a certain amount of skepticism of intellectual property, sometimes driven by over-aggressive use of it in many cases, that engineers have. And I think that should say something about what value intellectual property can have to innovation, positive and negative. If the people who are creating the innovation in the first place are skeptical, there's maybe more reason to be skeptical about it.
I feel like I have to...
Sorry, go ahead.
I just wanted to quickly comment on that, because I do think it's a really interesting point that, if you go out to parties in the Bay Area, you'll always sort of meet engineers. And if you mention if you're a patent lawyer, they always get very defensive and skeptical, and they start telling you how stupid they think patents are. And anytime I've been in those conversations and probed them a little bit on it, the thing that I find very striking is that they approach it purely from the lens of engineering. They tend not to think about who's paying for them to have the resources they need in order to actually, work with the technology that they're working with. And I've rarely heard any engineer who has a more kind of sophisticated understanding of finance or, what VCs look for in a company express the same level of skepticism. So there's a purity to their view that I think is typically unencumbered by knowledge of the downstream business effects of the systems they're proposing. And I don't mean that to be as dismissive as it sounds, but to hold the view with the level of passion and purity that I've encountered in engineers typically requires sort of willful blindness to the fact that their innovations are not being done in a vacuum, but they're part of a stream of commerce that requires certain predictable milestones that VCs look for, among them being, have you patented your idea? Once you have that, then you can more readily get financing. And so the system is so much more complicated, I think, than any one actor in it tends to understand. And I've definitely encountered the skeptical engineer before, and I've enjoyed pushing back on them. And probably I could have made more friends at these parties if I didn't do that. But
you could have gotten more free drinks for sure.
But for me, pleasure is in antagonizing and not in making friends. And so this is a great
I will push back. I will actually have to push back on that a little, because there's this idea that you have to have a patent to get VC, that there has to be a patent for innovation and for productization to happen. And I think that there's some truth to the idea that VCs do look for it. But I think you can also see, and there's a paper from Colleen Chien, who went out and interviewed VCs about how much they really care about patents and how much they worry about patent assertions against the startups that they're looking at. And the lesson you draw from that conversation with VCs is a lot less must have a patent and a lot more, they're nice, we like them, but we also are really concerned about patent litigation against the companies, and that's really more of a negative marker than anything else. If they don't have a patent, that's one thing. If they're currently being sued, we're not going to go put money into them.
Don't those two things tend to go hand in hand, though? If you've got a patent, aren't you less likely to be sued down the road?
No. Again, it's really, having a patent doesn't really protect you from being sued unless you can sue back. And
so back to ham sandwiches again.
Yeah, back to ham sandwiches. If you have a ham sandwich patent and somebody has a ham patent, they can still sue you.
Yeah.
And just
one final thought.
Go, Stefan.
Sorry, just one quick thought on this. So just to illustrate sort of my own view on how I think about this, there's often people who propose, for example, a meeting structure that's non-hierarchical. They'll say, isn't it nice to have senior people listening to junior people, and sort of they eliminate hierarchy in meetings, and that's typically presented as this radical, innovative way to get more people participating. And it's one of those things that sounds really good on paper, but what ends up happening when you eliminate hierarchy, as studies have shown, is the people who have sort of domineering tendencies tend to then just take over the meetings, because if you have a more introverted personality that can't shine in those circumstances, you're not going to have any kind of infrastructure to hold on to allow you to assert yourself. And I think there's an analogy there to the innovation landscape where in the short term, you can see there being a real value to saying, okay, well, there's no more barriers to entry. Patents are gone. Everybody just gets to innovate. But what would probably happen is power would consolidate. Entities would find different ways of blocking competition, and their trade secrets would be a great example. They would simply use their market power and trade secrets to keep incumbents out. They'd come up with different systems that are not transparent the way the patent system is. So it's one of those things where, you can get rid of hierarchies, and maybe that'll give everybody a chance to speak, but very quickly the domineering types will dominate and you will have no further recourse. And I see a similar thing in the technology landscape where people hate patents because they see the negative effects of them and they don't really think about the positive effects. And because the empirical process of proving one side or the other is so murky, you can always gather data that's going to support whatever intuition you have and cite it in an argument. So, I take your point that VCs don't necessarily only look to patents, but over time, I think if you were to get rid of a system as publicly accessible and transparent as the patent system and replace it with something like a combination of trade secrets and market dominance, I'm not sure that we'd be any better off. And there's no way to prove it empirically, as tempting as it is. And so my own view tends to be a little bit more of a hybrid of contingent possibilities and slap together answers rather than any kind of a definitive statement. But I am skeptical of the radical perspective of, patents are dumb, and if you got rid of them, it would spur innovation even more. I think that's probably wrong, and in any case, very difficult to establish.
Yeah, I'm not, I should be clear, I'm not at all suggesting that we should just get rid of patents. I don't think that that would be productive. I think it's just more drawing into question whether the system we have and whether the sort of one-way ratchet that's often seen towards stronger and stronger rights is the right solution. And one example I'll give is, I co-invented a patent. It's on a solenoid driver for automotive transmissions, and I think it's good technology, and we would have built it whether we got a patent on it or not because a customer was going to buy it. The patent didn't drive that innovation. We came up with it because we needed to sell it to a customer so that we could justify our jobs. And I think that that's actually much more common than we need a patent to justify this. And once you've come up with it, first mover advantage is often enough to provide the sort of reward structure that patents are articulated as providing. So I think the story of you need patents to drive innovation is maybe more questionable. It's a workable structure that we currently have, but it's not the only structure, and it's not the only thing that's relevant to how to promote innovation.
Excellent points from both of you. All right. Well, I think we will stop talking about the patent office and specific patent litigation and instead talk about patent legislation and some other legislative and policy issues. A few shows ago, Josh, we looked at a couple of your posts from Patent Progress without you on the show. So I thought we'd talk about them again with you on the show and see what is going on with the Inventor Protection Act. And if there's, first of all, to describe once again what it is for folks who didn't listen a few shows ago, and let us know if there's been progress towards its passage.
So I can answer the second question first because it's a very simple answer, and that is no. None of the current patent legislation out there is moving anywhere with the very limited exception of the fee-setting authority bill I mentioned earlier. The Inventor Protection Act, RILIA, and the Stronger Patents Act all were introduced as sort of markers, as messages saying, we think there should be stronger patent rights. They're not going anywhere. There is some active hostility from other members of Congress to these bills. And in particular, the Inventor Protection Act is just a terrible piece of legislation. The idea behind it is that patents that are owned by the people who invented them should get more protection. And maybe that's okay. I don't think it's necessary. I don't even think it's necessarily beneficial. The way the bill goes about it is completely counterproductive. And it's based on some really bad assumptions, mostly coming from a particular lobbying and pressure group who use, honestly, false numbers to justify their positions. So I've got two posts, and I think they're both wind up in the links that are available. The first one looks at just the numbers that they said justify this, and you look and they say, well, 85% of patents that get challenged in IPR get invalidated. That is true if you define things very narrowly and never look at the patents that the office says, yeah, we're not even gonna go all the way through this. This is completely okay. We don't need to go through the full process. When you look at the numbers that the patent office is actually declaring, it's around 45%. And you're picking and choosing when you go out and file an IPR. You're not filing an IPR on every single patent that might be litigated. So if you're being choosy, if you're a good lawyer, if you're putting some thought into it, it probably should be a fairly high number. There's also some other questions about cost, about patents being subjected to more than one IPR. It's relatively uncommon for it to even hit 2 IPRs. Almost none of them get more than 2 IPRs. And usually those are all filed at the same time and really work as a single proceeding. And cost, IPR is not cheap, like I've said, but it's still a lot cheaper than litigation, and it's a lot cheaper than litigation for the patent owner as well. So the cost argument is just out there. There's a lot of problems with the findings. And then you go to what the bill actually does, which is the subject of the second post. And it does a lot to kind of try and shore up for inventors different rights. It overturns a couple of Supreme Court decisions. It places some restrictions that sound good until you think about what they actually mean. So, for example, it says you can only have 7 days of trial and duration. That sounds great. You want a short trial, but I've been in courtrooms in Texas that run a very strict 9 to 5 day, and you get 8 hours of trial time every day. And I've been in courtrooms that don't run on that type of schedule. So 7 days meaning what? 7 days of trial time. It's badly drafted in that sense. Another, which I don't understand why they've put it in at all, is that there's a maximum of 10 discovery requests. So during litigation, you file discovery requests. You say, I want these documents. I want you to answer this question. And that's a lot of the cost of litigation. So the idea would be that this would reduce the cost of litigation. But usually it's the plaintiff who wants a lot of discovery. Defendants are not generally filing tons of discovery requests in comparison because they know most of the important information because they know what their product is. They don't have to do discovery on their own product. They have to do some limited discovery on the patent, but that's much more limited. And then there's a strict limit on pleading. So these are sort of like procedural issues that are just badly written. But I think the biggest problem is the damages provision, which basically says if you infringe 4 patents that are owned by inventors, your entire revenue, not your profits, but your revenue is gone. 25% of your revenue per patent. That's a pretty intense penalty for a product that might have 250,000 patents involved. And it creates a very weird incentive for companies to kind of find the original inventor and give them the patent back, but in a way where they're getting a significant portion of that 25%. If you're looking at maybe like a 30-cent royalty per device, and all of a sudden you can get 25% of the revenue of the device, if you're looking at hundreds of dollars, you'll give the inventor half of that, no problem.
Wow. So, that is an interesting development. If should this thing pass, it would take a bunch of the NPEs that we've been talking about and give them a whole new strategy, going back to the inventor and seeing if they can cooperate on a way for everyone to make money again.
I don't see any realistic chance of the Inventor Protection Act passing. RILIA is similarly unlikely, and I think that was the one you talked about with Professor Vishnabak a few weeks back.
Yep.
And then stronger patents is older and has been around a while longer, and that is probably the most likely to see any action of any of these. It has, I think, the most co-sponsorship, the most effort behind it, and is also the most reasonable. I think it's not a good bill for a lot of reasons, but when you compare it to RILIA and the Inventor Protection Act, it looks a lot better.
So I have a Washington procedural question for you about this Inventor Protection Act, which is the brainchild of my own congressman, Dana Rohrabacher, who is facing a stiff challenge here in the November midterms. If he gets unseated, he's held his seat since 1988, but if he should manage not to keep it, what happens to proposed legislation that he has put forward?
So during the lame duck, it's still alive. Once the new Congress gets seated, any bill that wasn't passed is dead. You have to reintroduce everything. And this is true in the Senate as well. So even if a senator has kept their seat, they still have to reintroduce everything every 2 years. So it would be dead unless somebody, and I think there are a couple co-sponsors. I think Massey, who introduced RILIA, is on it, as well as a couple other representatives. But he would have to find somebody to take the bill from him. That's possible, but
that makes sense. Okay, Matt, any questions about this?
Yeah, no, I think this is really interesting to think about, and the damages are really striking. As you mentioned, there's 250,000 patents, and that's typical of a cellular device, which a lot of these cases involve. So, just a lot. And it seems like, again, if there is a proposal that seems reasonable, it's looking at how patents are granted. Would seem to be the most logical conclusion if you want to improve the patent landscape, is to either put more resources or time into making sure that when they're granted, they're accurately granted.
All right.
Yeah, you'll hear you'll hear a front end, back end term sometimes. So the front end is the patent office making sure that as much gets through there that is valid and as little as possible that is invalid. And then the back end is the courts and the IPR, the sort of second review of, well, this is out there, but should it really have been? So I think both have to be part of the discussion. You can't get everything at the front end, but you don't want to rely on the back end for everything either.
Seems like a good approach. Stefan?
I think of every congressperson as a public servant auditioning for their real career, which is a lobbyist. And I think this legislation is sort of a show of just how low this person is going to be willing to go once they're in the lobbying industry. If you're willing to sponsor this legislation, just imagine what you'll be willing to do once you're a lobbyist. And this is like a business card being distributed to the industry saying, look what I'll do for you. So that's all I'll say about that.
Yeah, that's a good point. All right. Well, our governor here in California was busy last weekend. He signed probably more than just two bills that we're going to highlight today on the show into law. One was California's net neutrality bill. It will take effect on January 1st of next year, 2019, unless it gets derailed by, for example, an argument that it is preempted by federal law. So I'm not quite sure, exactly procedurally what's going to go on between now and January 1st. But I suspect that we'll see some rushed consideration of the Justice Department's argument that because the state has legislated in an area that the argument is being made should be reserved to the federal government, that perhaps this piece of legislation should not take effect, and it may not. So there are good arguments why it should take effect, and I think we'll see the parties play those out. What California and those in support of the law assert is, hey, the government actually, via the FCC, removed the regulations in this area, so leaving it wide open for us to do what we'd like to do, and Congress has not acted. So we're going to see whether that carries the day, or the argument that, hey, we've got this overarching scheme of how we regulate telecommunications, and what you're trying to do, California, definitely treads on the federal government's province there, even if we haven't specifically done anything, or we removed the specific regulations that were in the area that you're now attempting to adopt for yourself. So it should be an interesting few months as those arguments play out. Matt, do you want to try and ballpark the outcome?
Yeah, I think you set up the argument very well. I'm not sure how it'll come out. I think that the government has a conceivable justification that this would fit under the Commerce Clause, but it's so fact specific, and it's so it's based upon what they're going to do too. There's opportunity for the FTC or the FCC to step up their actions, and at least part of the authority to legislate or to do rulemaking about this area is still granted in the FCC or the FTC. So it'll be an interesting question of whether inaction or at least lessened action affects the outcome of whether they have the rights to preclude others from acting in that area. But yeah, no doubt this will be something we talk about for a while.
Mm-hmm. Stefan?
I'm curious to see what happens with the argument about our position is we're not regulating, and that is in itself a regulation. I don't know enough about the field to say whether that's a credible argument or not, but my understanding is that the preemption argument essentially boils down to, by saying we're not doing anything, we are in fact doing something. And it would be interesting if that is upheld, because you could preempt a lot of things by just essentially very efficiently, in fact,
yes,
with that. So we'll see what happens.
And very selectively, the ones you decide to come in and say, hey, we haven't done anything there, so you can't.
I think that the FCC's powers were going to be preemptive, and therefore they were going to tell what companies needed to do. And so I don't think the government's argument is going to be that we're going to do nothing and therefore we can preempt, at least from an argument, that may be their actual policy and probably is. But the FTC's authority is to retroactively set fines for corrupt activity or something, some of that. So at least from an argument perspective, that's probably not going to be how the lines are drawn.
Mm-hmm. What do you think, Josh, with a more Washington, D.C. perspective in your pocket?
So I think that I think it is a really interesting preemption question, and I think at the end of the day, it may go to the administration, which is I have mixed feelings about. I think that the policy that California is setting is generally a good one. I'm generally in favor of net neutrality. I also am reticent about state-level regulation in a lot of cases where things are not really local issues, and internet policy is hard to say that it's a purely local issue. So I have some pretty mixed feelings about it on a policy outcome, but I think at the end of the day, the argument that the FCC has the statutory authority to regulate this, it doesn't matter whether they've actually made use of that authority if Congress has granted it to them. I think the preemption analysis winds up with California not having the authority to go where the federal government is preempted.
Right. But it does come down to that big question of whether the FCC has that authority and it's been delegated that from Congress or not. People have been waiting for Congress to step in and act on this for years. Maybe Congress will decide that this would be an opportunity, but it seems like nothing along those lines could conceivably happen before January 1st, 2019. What do you think, Josh, based on what you just said about this being a telecommunications issue that's not, it's hard to see how it's local specifically to California. Wouldn't you say the same thing about privacy law, though? And California has a ton of both older and recently enacted privacy law that it is busy implementing.
So when I said that I have concerns about it being local, those aren't legal concerns. They're just purely policy concerns of, I think that they create difficulties. I don't think that there's something barring local regulation in and of itself. I think that here the issue is really just preemption. I lost the first half of your question.
So did I. So let's just move on. Let's talk about one other interesting thing that Governor Brown did last Sunday, and that is this other piece of legislation that now says that boards of directors of public companies in California now have to have a woman on them, and any boards with 6 or more members have to have 3 women on them. And there are a number of companies, including large tech companies in California, that are going to feel the effects of this. They have a year to bring themselves into compliance. And actually, it's by mid-2021 that they have to comply. And there have been a number of articles. There's a cool one at Money Watch that talks about the nearly 100 California companies that this affects. And then there's one at Wired that focuses more on the larger companies, including Apple, Alphabet, and Facebook, that will have to add women to their boards as well to be able to comply with this law. Any thoughts about this, Josh?
I think this seems like a pretty good idea. I'm all for more women on company boards and more presence in general in tech and policy and law. I don't even have anything beyond that. This seems like a really obvious solution.
One thing I wondered about when I first started reading this is, well, there are a lot of companies that are headquartered in California but may be incorporated elsewhere because people tend to strategically decide where they're going to be incorporated based on favorable laws in various jurisdictions. Delaware tends to be a place where lots of companies are incorporated. But this particular piece of legislation focuses on where the company is headquartered. So you're not saved by incorporated elsewhere. Stefan?
It's interesting that you say that because I'd actually read the opposite. So maybe maybe I am misinformed, but my understanding was that if you were incorporated in Delaware and headquartered in California, then the law would not apply to you.
That's not how I read it. I'll go back and double check it. But no, it says all the coverage I'm reading. Let's look at the actual text. Is California headquartered companies is how it is described. While I'm doing that, Matt, any thoughts?
Yeah, I think that this, first of all, I think it's a fine policy thing. I'm not sure. I think that it might run up against the internal affairs doctrine, though, which is that generally you can regulate an activity, that most of these companies are going to be from Delaware, or incorporated in Delaware. And so the internal affairs doctrine tends to protect those decisions which are inherent to the corporation. So stock, ability to vote for stock, ability to elect directors. So this seems like something that's, fundamental to the corporation and therefore fundamental to Delaware. But from I can't imagine what public corporation is actually going to challenge this. If this was against private corporations, I could see individuals challenging this. But could you imagine the public outcry if Apple was like, no, we don't want to elect more women on our board of directors? So, I think that's maybe the more and also I think that it also brings up the question of, the old contracts clause in terms of internal state. If you remember Dartmouth College versus Woodward, that was essentially about the ability of one's own corporation to change the internal rules of a corporation. But here's another state essentially changing the governance procedures of a corporation. So your libertarians may want to bring out that old argument. But yeah, I can't imagine this actually being challenged by a public corporation. I think the outcry would just be way too much.
Yeah, I can't see that happening either. What were you going to say?
So I took a quick look at what I was looking at, and you're right that the law is drafted such that it would cover Delaware, for example, but there's law professors are already saying that would likely be found unconstitutional for the reasons Matt stated, but also as Matt pointed out that the actual likelihood that anyone's going to challenge this seems like unlikely. Certainly, Apple wouldn't do it. Also, Apple's incorporated in California, so in that particular case, it wouldn't apply. But the you could imagine. I don't know Hobby Lobby's corporate status, but you could see a company like Hobby Lobby that has not been shy about pursuing court action in defense of sort of conservative ideas of its owners. I'm not sure if Hobby Lobby is publicly traded or not, but some equivalent publicly traded company that really doesn't want to do this could probably survive the political blowback. And it'd be interesting to see what happens. There's a little bit of, which isn't to say that I think this is a bad policy. It's a great policy. It's just, it'll be interesting to see how it's actually implemented over time.
Right. And, Hobby Lobby does not appear to be one of the players here that would be implicated because they're not headquartered in California. You know who is, though, relevant to our discussion today? Acacia Research here in Newport Beach is one of the public companies with no females on the board, or not the sufficient number. What were you going to say?
It doesn't have to be Hobby Lobby. Just some conservative leaning company could foreseeably challenge this, and if it were to challenge it, the Delaware piece, I think, probably wouldn't survive. Right.
Acacia, I think we mentioned earlier, is one of the big non-practicing entities. All right. Any further thoughts on legislative matters before we move on, gentlemen? Going. All right. Let's cobble together some sort of MCLE passphrase from this discussion. What should it be? Just let's make it women on boards as our second MCLE passphrase for this episode of This Week in Law. I neglected to mention earlier that the reason we put these passphrases in is some people like to watch or listen to our show for continuing legal education credit or for continuing education credit in other fields. So we put these phrases in case your oversight body needs to have some verification that you actually watched or listened to the show. We have more information for you about that at Victor, help me out again. I had it in the rundown and then I took it out.
twit.to/MCLE.
twit.to/MCLE, where you will find our page that has information for lawyers in the United States about how you might want to go about applying for credit in your jurisdiction, or even if that might be possible or not. So we now have our 2 passphrases in, and hopefully you're going to stick with us for the rest of the show because it's going to be interesting. Our next topic is privacy. All right, I put a couple of privacy stories in that I thought were kind of related to one another strangely. One of them is this cafe near Brown University that operates on a no cash basis. You don't have to pay to get your coffee and donuts or whatever else they sell. If you are a student, that is, at Brown University, the professors can frequent it too, but they have to pay. But the students, this Shiro Cafe, wants some other form of compensation from. It wants their personal information. It wants to know what they're studying, their major. It wants their name and their email address. And it wants to ultimately be able to put potential employers together with them. It wants to have job-related meetings or encounters, maybe job fairs at the cafe where certain employers know that they're going to be able to interact with certain potential candidates. So what's interesting about it is this compensation based on data about you. And there's a piece at NPR writing it up, and they interviewed one of the students who said, so this really doesn't bother me, and I'm enjoying the free food, and all the information they're collecting about me is publicly available anyway, so why should I be concerned about it being aggregated and used in this way, was her rationale. What do you think about that, Josh?
I think that's interesting. I think she's probably right that most of this is publicly available, so you might as well benefit. And that is sort of the deal with a lot of internet services is you're going to get some of my personal information and some data around me, and I'm going to get free service from you. This seems like just an extension of that into the real world and maybe a little bit more upfront about it. And as long as they're being clear, and it's not 100% clear from the article to me, as long as they're being clear about what they're doing with it, I don't know that there's a problem.
All right. I think I probably agree with you. It still strikes me as creepy as heck, though. What do you think, Stefan?
It renders in stark relief what's happening anyway, and I think that's what makes people uncomfortable. You know, they might pay money, and as they pointed out, this information is all publicly available. It's being compiled. If you click through a website and buy something, you reveal a lot about yourself. So I think it's being confronted with sort of how the sausage is made that makes people uncomfortable here. And I think maybe they're right to be uncomfortable, but it's kind of if anything, it might inform people and kind of get them thinking about the issues in a more direct way rather than just sort of assuming something's going on behind the scenes that they don't need to think about. Of course, it's causing me to think up all sorts of gross Black Mirror-ish hypotheticals about where else you could take a business model like this. But I'll keep those to myself.
Right. And of course, you have to be confident, or you would want to be confident if you were one of the students partaking in this ecosystem, that the data that was being aggregated, I won't say the data that's being collected necessarily, because as this one student pointed out, maybe they could do this without the students giving them the nice bundle of data all at once. That could probably be done. It would probably be more costly. But now that the aggregation's been made, I guess you'd want to be comfortable that your data wasn't being sold, that these associations with you were not being monetized in some other way that you weren't aware of, and that it was secure. And the company operating the cafe says, yes, we're not going to sell the data, but who knows what they do down the road. Matt, any thoughts?
Yeah, I think that this is, I think it's shocking because it's so in your face about it. But, your trade-off of going to your local coffee shop is that they're, if you have to enter your email to collect there, they're collecting at least half of the information that, the valuable information. They're not collecting what you're studying or, that you're going to school, which you have to go to this cafe. But from a trade-off perspective, it doesn't seem you're probably getting a better bargain by going there.
Right. So the other story that I sort of wanted to consider side by side with this was highlighted for me by H. Feld on Twitter. Nofeld is his Twitter handle. And it's a year-old story that I think came out in the wake of the Equifax breach a year ago that seizes on, it talks a lot about Equifax in general and the role that it plays in people's lives and how they're not really familiar with what these credit reporting agencies do, or people don't spend a lot of time thinking about it. But the thing that got pulled out of this New York Times piece sounds a lot like what we were just talking about. One of the things Equifax was working on was a new system that searched 4 billion public tweets for keywords like car and automotive lease, and then it would pair those tweets with the person's Equifax credit file, and then that could all be sold as a package to, say, a potential car leasing company, so that they could know right off the bat whether this person interested in a lease was a good bet for becoming a customer, I guess a good credit risk, and whether they could be, I guess they could do with that data what they wanted to, if they wanted to target them or not target them, I guess, based on what their credit report said. Do you feel any differently about this one, Matt?
Yeah, I think it's a much more complicated issue, mostly because, unlike the coffee shop that can just open up and operate, like I can't offer a competitor to a credit reporting. Like there's licensing along that, and so the ability to have a reasonable alternative in this space is not real. And so this is the sort of space where you do look to sort of like a common carrier issue where you do look for more regulation resolving privacy issues, and that's why it's so big of a deal. They're a large part of their business is selling information to government agencies about consumers and providing services to government agencies. So I think that there's significantly more risk with your privacy in these instances.
All right. What do you think, Stefan?
App where instead of talking about interests and hobbies, you just put up your credit score and some biometric data and sort of let it go from there. I think that's where this is heading.
Let's hope not. Josh, you were gung-ho on the cafe. What do you think about Equifax and public tweets?
I think it feels very different because the cafe, it's a pretty honest deal of you give them your information and they give you a drink and you know what you're getting, you know what they're getting. It feels very transactional and not objectionable. Equifax feels much more creepy to me. And I think it's interesting that the students were the ones who are doing this because I think it says something about what norms of privacy are and what privacy concerns are for younger people. I'm old, so I didn't grow up with the internet until I was in my teens. But I think that people who grew up with that have a very different conception of what privacy is and what public information is. I think there's some really interesting work that's been done on it by Donna Boyd at NYU, I think. Equifax doesn't feel like that. It feels like they're trying to stalk everyone, and that feels a little creepy.
Yeah, I don't know. There's a third party, maybe an undisclosed third party or several third parties involved in both cases. I mean, the students may be told that, hey, we're going to share this information with various employers who may want to talk to you about jobs, but I don't think it's limited to that. It felt like they could be advertised to in other ways. There was some mention in that New York Times piece NPR piece about the cafe that the sales staff at the cafe had been trained to come up and discuss with customers their partner products. So there would be sort of this direct interstitial ad going on while you're having your cafe experience that, again, you could agree to. It doesn't sound that too dissimilar to the way we advertise here at the TWiL network, and everyone knows they're going to be advertised to while they're listening to our shows. Or if they don't know going in, they're going to figure it out pretty quickly. But we're not harvesting their data in that way. Anyway, and then the Equifax situation, there are third parties too, but the only way that you'd know what was being done with your matching your publicly available information with your credit file is, I hope there's some mention, or there would be some mention of it in their privacy policy, but I'm not even sure if they'd decide that was something worth disclosing if they're merely matching up public data. And I don't know if they'd be required to disclose that. So I thought it would be interesting just to toss out for consideration and discussion. What do you think, Stefan, about the privacy policy issue?
It's such a moving target because it always references people's perception of what they're entitled to, which is constantly changing. And so in the case of Equifax, I do see it as being particularly invasive in the sense that people's credit scores can determine so much about their lives, often without their knowledge, or not so much without their knowledge, but without their kind of control in a lot of senses, that using that information and pairing it to kind of commercial interactions just inherently feels like you could really disadvantage large groups of people in ways that they can't do anything about. And so there's obvious concerns there that I wish were better regulated. I don't know enough about the framework to really speak with any kind of detail about it, but there's some serious red flags there that don't seem to be getting the attention they deserve.
Yeah. I mean, on the one hand, Equifax would have to disclose if they're sharing data with third parties, their data on you. But then what I question whether they'd have to disclose is if they're providing that extra service step for their marketing third-party partners of going out and aggregating the public data and putting it together with your credit file, which really they're the ones that could say, hey, this is this individual and their credit file, and here's what we've found about them online. As I talk through this, there's the possibility for false positives there too, where they're maybe matching somebody's data up with the wrong public profiles. And that could certainly be damaging and cause some situations down the line.
Sometimes I like to click on really expensive things online just to give my data overlords the sense that I have better taste than I actually do. And so I can get nicer advertising directed at me. And you could imagine that kind of, gamesmanship in this environment too, where people feign interest in things that create a data profile of them that make them seem more sophisticated or commercially sound than they really are. And you can go you can imagine consultants, kind of like a college admissions coach. Like, here's an internet browsing coach that'll tell you which ads are indicative of people with bad commercial habits or who are unreliable. Like, if you click on this pair of shoes, we're going to assume that you live in a trailer park in the middle of nowhere in Nevada. If you click on this pair of shoes, you're on the Upper West Side. And let's provide some guidance for which ads you should pay attention to so that your triangulated credit score and commercial score, whatever you want to call it, ends up allowing you to get a better mortgage or something. I mean, it sounds ridiculous, but effectively, it's not implausible.
It's not. And I listened to TWiL last Sunday where Father Robert Ballister was one of the guests, and he talks about how he likes to fuzz his online footprint and make sure that it's not very accurate to who he is, and that maybe, you're taking it a step further. Not only is it not accurate, but it's specifically misleading in ways that perhaps someone might want to mislead marketers, which I think is just a fascinating concept and a whole business model waiting to be born. Matt, were you going to say something?
Yeah, just that it is pretty strictly regulated what can go into your credit score, and there may be positives that you're missing out on that could go into someone's credit score. Someone who, you essentially get right now you get an incentive for having a credit card and using a credit card. So, if you can include, for instance, your Airbnb rating into your credit score as your worthiness to buying a house, that may be beneficial to people who otherwise wouldn't want to take out credit cards. So there are negatives too of not being allowed to add these things, but I'm glad that my shoe selection does not tell you that I live either in a trailer park or on the Upper West Side.
Okay, just going down a bit of a rabbit hole here, I will mention that I saw a couple of news articles recently about a shoe company, a very high-end shoe company called Golden Goose that makes tennis shoes and other things. I think they make boots as well. But these are like $500 and up items. But the funny thing about them is oftentimes they're doing distressing to the shoes, much like you've seen distressed jeans over the last several years that are just ripped to pieces and tattered and torn and cut apart in various ways. So that's what these shoes look like. They're not all of them, but some of them are very distressed. And the company's taking a lot of flack about selling shoes that look like you are very down on your luck because or maybe just you haven't wanted to replace that particular pair of shoes. One of them even had like a duct tape kind of arrangement going on. Yeah, there we go. And where there are actually pieces of tape on the shoes, making it look like you've taped them back together. But look, yes, I believe Victor has found a $600 pair of Golden Goose shoes. Now, these are not terribly distressed. These are all sort of bedazzled and looking like, I don't know, there's pen on that one, like you've taken a Sharpie to the shoe, only they have done so for you. Maybe these are the perfect blend of confusing your online trackers.
I want them to open a marketplace for distressing specific shoes so that I can participate in distressing these new sorts of apparel.
That would be fun. How can we tear up the shoes?
I'm not sure I would get a bonus for being the one who distressed them, but other people may be able to get bonuses for distressing things.
Yeah. Go ahead.
On this rather strange topic, I cannot recommend highly enough. There's a New York Times article a couple months ago titled "My 8-Month Search for $900 Sneakers," and it's about the Balenciaga Triple S sneaker. I highly recommend it if you're at all interested in high-end footwear and the ridiculousness that surrounds it. It's a fascinating look into a subculture that I am not a part of, but I find fascinating from a distance. And I particularly love the nickname that they have for each other, which is Hype Beast. Apparently that's what they call themselves. So if you're a hype beast, you buy these sorts of $600 distressed shoes. And so it's
that's actually an Instagram account that follows these kinds of products and highlights them. So I don't know which came first, the chicken or the egg there, if hype beast as a term existed independent of the Instagram account or predated it. But it is one of those very, how do you follow the really high-end stuff? It's one of those accounts on Instagram. And I called this a rat hole when we started to go down it, but as we talk through it, there are definite intellectual property issues here that are pretty interesting. Like, could you patent the ability, your distressing techniques, or is there some sort of copyrighted design in having tape on a shoe that I think could get pretty interesting as these things go along? Because I can think of lots of people who might want to tape up their shoes and sell them for $600.
Well, that's isn't that the Star Athletica case from last Supreme Court time?
Yes.
And exactly. What are those famous red shoes that you...
Louboutins.
Louboutins.
Yeah. See, I'm glad I didn't know that.
The only reason I know that is taking trademark law.
Mm-hmm. I wish I could say that I was the only. That was the only reason I knew that, but it's not. Okay, so let's get into our concluding material for the show. Let's do our tip of the week first, which is for anyone who is concerned with airport security, the differences in traveling from place to place. Let's see. Is this? Yes, New Zealand, which has done this. I was going to say Australia, but it's New Zealand, which has decided that under its Customs and Excise Act of 2018, which just came into effect, if you are asked and or demanded to unlock your electronic device so that it can be searched and you don't comply, you can be fined up to $3,200. So in the U.S., how this kind of works is they just tell you you're not going to be able to come into the country if you're not going to cooperate with the border search agents. Here, anyone who refuses can be prosecuted, I guess, there in the country. They're going to keep you there and then prosecute you and fine you up to $3,200. And we had some stories in the rundown today we haven't had time to get to. Maybe we'll do them soon in the next couple of shows that talk about these differences between having password protected device access or biometrically protected device access, specifically facial recognition, and how that's beginning or may start to begin to play out at borders. But this one does not seem to make a distinction, this New Zealand law. It talks about passwords, so it's clearly anticipating that. But I would think that you might have an issue in New Zealand if you refuse to let them put the phone up to your face so that it would unlock as well. So tip for those traveling to New Zealand, just be aware of this new law that went into effect there. Our resource of the week comes courtesy of Josh, who, aside from having his amazing patent progress blog that we have already plugged, has a number of great patent-related resources. One is super useful. You probably would have liked to have it at the beginning of our discussion today. It is its dictionary of patent-related terms. So anything and everything patent seems to be covered here. And if should you ever be stumbling across some dense patent discussion, Josh has you covered and has easy definitions of what all these terms are. You have lots of resources in connection with your blog, Josh. Anything else you think people should know about?
I think the blog resources, I'm sorry if you hear a dog barking. She's getting anxious about dinner at this point. Hi, Sasha. The dictionary is very helpful. And honestly, if there's a term that I use in a post and you read it and you don't know what I mean, email me so that I know that you didn't understand it and I can add it to the dictionary. I would prefer to help people out rather than to assume that you know exactly what I'm saying.
Sure, that is wonderful. Thank you. And then, of course, it would not be an episode of This Week in Law without our animal selfie of the week. We have done animals with Snapchat accounts before, but I don't think we've ever specifically focused on people who enjoy applying the Snapchat filters to their animals. I don't know if these technically count as selfies because I do believe these are portraits of animals by the owners with their own Snapchat accounts, but then the filters applied as well. So we can split hairs about whether the animal might have a colorable claim to the copyright or not. The other thing I thought was hilarious, and let me just pull it up here. Speaking of New Zealand, I think that's where this, app comes from. It is, if you're not a Snapchat user, but do like the concept of using a Snapchat-like filter on your pet, there is an app that provides you with very pet-tailored filters. And it is called, let's see, what is it called? They talk about the app. They have a video of the app. It is called Selfie. No, that's something it partners with. I don't know. You're going to have to go to our discussion points to get the specific app name if you are interested in it. And there's a video there you can check out. And thank you, Victor, for focusing so intently on intensified Doge. All right. That is going to do it for this episode of This Week in Law. Speaking of dogs, Josh has one to go feed. So we're going to let you go, Josh, and apply whatever filters you need to your dog as it's eating dinner. Thank you so much for joining us today on This Week in Law. It's been really fun. We learned a lot.
Thanks for having me. I had a good time.
We already had you plug some resources on your blog. Anything else you want to mention to people, things you're going to be speaking at, writing about, etc., before we sign off for today?
Patent Progress, Project Disco. If you are in the DC area in March, I will be sound designer for the production of Urinetown at the Georgetown Gilbert and Sullivan Society. So feel free to come out and check that out.
Yeah, tell us more about that. We were talking about that before the show. So explain what you're doing there.
So, I mean, since high school, I've done sound design for theater on and off throughout that period of time. So I'm finding all the sound effects, acquiring the proper licenses in some cases, and making sure they play back at the right time, designing background sound for various environments, and putting it all together into a performance. That's what sound design is, and I've been doing it for a while, and it's a nice break from law and policy.
So you've got some Georgetown law students who are taking advantage of your talents?
Yeah, well, I did it while I was at school there, and they keep calling me every once in a while and saying, could you work on this show? And in this case, it's actually a friend and a classmate who's directing it. So we'll both be going back to be alumni and do theater things. So
it's Gilbert and Sullivan, which show?
The March show is Urinetown, which is not a Gilbert and Sullivan show.
Oh,
it's the Georgetown Gilbert and Sullivan Society. Tonight, they're actually doing Trial by Jury. So if you're really bored, and I'm not a Gilbert and Sullivan fan, I should clarify. If you're really bored and want to see a mediocre show, it'll be a good version of it, but it's a mediocre script. Trial by Jury tonight. Otherwise, come by in March. And in the meantime...
I was not about to accuse you of being the very model of a modern major general. Now I know not to. All right. Thank you so much for joining us today, Josh.
Thanks very much.
And Matt Curtis, always a pleasure. Thanks so much for joining us.
Yeah, thanks so much. And thank you, Josh. And just want to point out as a wariness that every listener should, or potential guest is going to have, that Victor's was able to pull that fun fact out of his sound check with Josh. So watch out when you're coming on the show. He'll find the most interesting thing about you and make sure it's publicly known.
Yes, mm-hmm. Absolutely. Also, Stefan Spida, wonderful to see you again. Thank you so much for joining us today.
Glad to be here. Just upset that you stole my model major general joke that I was going to sign off with.
I forget. That's Pinafore or Penzance? I want to say Pinafore.
It's all just one long script as far as I'm concerned. It's all just one long, interminable script.
All right. Well, here's Buttercup signing off for the day. Hope that you all have a wonderful week. We will see you next week on This Week in Law. Until then, take care.